DeShany versus Winnebago County Department of Social Services and their employees. A brief summary is that the mother of an abused child, that would be Joshua DeShany, brought a action against Winnebago County Department of Social Services and its various employees for failing to intervene to protect the child from beatings from his father. The United States Court of Appeals, the Seventh Circuit, affirmed the court's order granting summary of judgment in favor of the respondents. Further facts would include that in 1980, a divorce court had granted Randy DeShany custody of his son, 1-year-old Joshua DeShany. In 1982, Randy DeShany's then wife had reported to the Winnebago Police Department that the father was physically abusing Joshua. The Winnebago County Department of Social Services had investigated the case and found no allegations of child abuse, and they did not remove the child from the home, but did close the case at the time with no further investigation. So in 1983, the child was hospitalized for injuries that promoted another investigation from Department of Social Services. But Department of Social Services did not remove the child from the home again. They found that there were no issues of child abuse, and they found no allegations, and they closed the case. However, the staff member who was on the case at the time did indicate that she believed the child was in an unsafe environment. After numerous child abuse reports, DSS never removed the child from the home of Randy DeShany. The assigned caseworker, however, did implement some requirements of the father. One was that the son, Joshua DeShany, would attend preschool to help him get out of the house and have some separation from the father, and that the father would obtain counseling. However, this did not take place. In 1984, 4-year-old Joshua had suffered extensive brain injuries as a result of the abuse experienced by his father, Randy DeShany. Joshua had been deemed to be disabled as a result of the physical trauma experience. Randy DeShany was charged with felony child abuse and sentenced up to 4 years in prison. Joshua's mother, Melanie DeShany, filed a lawsuit on Joshua's behalf against Winnebago County Social Services and their employees. And the lawsuit states that the employees and DSS had deprived Joshua of his liberty without due process of law, in violation of his rights under the Due Process Clause of the Federal Constitution 14th Amendment, stating they failed to protect Joshua against violence and failure to intervene despite knowledge of a high-risk situation. So the question is failing to protect an individual against private violence a violation of the Due Process Clause of the 14th Amendment? The answer out of the proceedings was no. No. The Due Process Clause of the 14th Amendment does not execute the state's specific duty to protect private actors or citizens from violence if the state did not create the harm. The Due Process Clause generally confers no affirmative right to governmental aid, even where such aid may be necessary to secure life, liberty, or property interests of which the government itself may not deprive the individual. Um, the Chief Justice Rehnquist court majority was 6-3. Court opinion number 1 concurred that the Winnebago Department of Social Services and their employees had no legal responsibility to protect Joshua because the Due Process Clause in the 14th Amendment does not require the state to protect against the attack of private actors. The DSS and its employees were not found to breach any constitutional violation of the petitioner's right of due process. Furthermore, opinion states the damages were perpetrated by the father and not the state. Furthermore, Rehnquist stated nothing in the language of the Due Process Clause requires the state to protect the life, the liberty, and the property of its citizen against invasion of private actors. Winnebago did not violate DeShany's rights, and the decision of the lower courts were affirmed. Rehnquist acknowledged the severity of the actions against the child. If the state had removed the child from the father's custody, the state itself would have faced the charges presented in the case due to the petitioner Joshua being underneath their care. However, the court confirmed again with the lower court's decision in favor of the respondents. The dissent stated that the state's knowledge of the individual's predicament and its expression of intent to help him. Examples will include the Department of Social Services involvement in the case and its having learned of the violence inflicted on the child. Vernon essentially equated this to a limitation of his freedom to act on his behalf. In other words, the involvement of the Department of Social Services effectively precluded a non-government entity from intervening, and when the department failed to act on its suspicion of abuse, it became morally culpable for the harm that it ensued upon the child. So, and all of that, it basically states that the Supreme Court found the action of the father to be reprehensible. However, the court determined the 14th Amendment did not require a state or local government agency to protect its citizens from private violence or other forms thereof. So how does this relate to public administration? Well, the public administration law, it needs to examine how ethical problems associated with decisions of institutions affect constitutional freedom. The role of administrators has drastically changed over the years, and public administrators have to be educationally equipped to address legal issues within their environments. With DeShany, it is clear that the Constitution failed. They failed this child, who society entrusted his care. Further, injury occurred when a social worker exhibited incompetence in her ability to communicate the urgency of Joshua's case. We need to create new policies in state and local governments to hold employees and agencies responsible to protect the people. Administrative failure manifests itself in many forms, such as overregulation, It causes administrators to exert power unfairly or underregulated, as what was seen by the social worker in the DeShany case. The court gave no reasoning behind the worker's poor ability to take steps to protect the child with knowledge of his situation. Based on our reading by Stephanie Newbold, there are practical ideas that support moving toward a constitutional school for the field of public administration. There is a moral oath to uphold the Constitution that leads the administrators to implementing value and beliefs that are vital to those they serve. Another important factor in consideration in Rosenblum's analysis demonstrating the type of partnerships that courts maintain with public servants and the agencies in which they serve. This relationship builds on the nation's separation of power system of government and provides insights into how the courts, like Congress, play a vital and active role in public administrative states. Thank you.